Welcome to Free Kiwis. We're delighted today to be joined by Nadine Strossen. Nadine is one of two senior research fellows at FIRE, that's Freedom and Individual Rights in Education, the other being Jacob Mchangama, who has been a previous guest on this podcast. Welcome, Nadine. It's great to have you.
I'm delighted to be here. And let me make one friendly correction, which is you gave the former definition for about 25 years since its founding of the FIRE acronym. Last year, FIRE expanded its mission and changed the meaning of the last letter in the acronym, Foundation for Individual Rights and Expression, because the free speech issues, the intellectual freedom issues on campus that had been so severe and requiring FIRE's attention for decades have now expanded and seeped out into the larger society in the United States. And there simply was too much free speech work to be handled by pre-existing organizations. And, you know, this is a really important issue because in the United States, some people who would poo-poo complaints about so-called cancel culture and the woke attitude that was overtaking campuses and leading to massive self-censorship by professors and faculty members and students with respect to controversial issues for fear of being accused of being insensitive or offensive, some kind of an ist or some kind of an obe. A lot of people poo-pooed that and said, oh, well, just wait for the students to graduate and then they'll encounter the real world and they'll understand that they can't get away with that kind of suppression of speech that they find offensive. In fact, what's happened is exactly the opposite, that suppressive culture that has been on the ascendancy on campus has come with the students when they graduate and is now pervading businesses, law firms, publishing companies, you know, even institutions and organizations that have traditionally been very supportive of free speech, including journalism, librarianship, I already mentioned publishing, entertainment. The younger ranks of those professions are demanding the same kind of so-called sensitivity resulting in suppression of certain views. So, you know, that certain books shouldn't be published, that certain op-eds shouldn't be published, that certain plays shouldn't be produced, and so forth. So, which is a long way of saying, you know, the change in the last letter E for FIRE really explains a lot of the free speech problems that we're facing in culture in the United States, way beyond campus.
Well, I think of the title of the Andrew Sullivan article a few years ago, We're All on Campus Now. And his point was a lot of these trends we've seen on college campuses, especially in the United States, are now sort of society-wide, and not only in the United States, but also abroad, also in New Zealand. And that's what struck me particularly about the Posey Parker episode in Auckland when she was not allowed to speak and then she had to cancel her talk in Wellington as well and basically leave the country. It seemed to me that was the moment when campus deplatformings or deplatforming people from campuses became deplatforming people from entire countries. And I think that's quite a scary shift.
What's next? The planet, I suppose. And this is such a, it should go without saying, but it is such a loss to every single person in this country and beyond, regardless of what your views may be about what Posey Parker would have said or could have said, because the same attitudes and stances that led to her and her audience being deprived of the opportunity to speak, to listen, to question, to discuss, can affect any potential speaker and any potential audience when the political winds shift and what is an unpopular position today becomes popular tomorrow and vice versa. the history, the term that the U.S. legal system uses for the situation that developed there is a heckler's veto.
Yes.
When the disruptive, and in this case I understand even violent or intimidating protesters went far beyond the right to peacefully, non-disruptively express opposition to a speaker's ideas. That's core free speech. But when it goes beyond that to prevent a willing audience from hearing a speaker, even through means of physical intimidation, we call that the heckler's veto, that in effect those who are heckling, objecting to the speaker's message are vetoing the message altogether. And interestingly enough, that concept as being anathema to First Amendment free speech rights of speakers and audience alike arose during the mid-20th century civil rights movement in the United States, when the heckler's veto was a favored tactic of those who opposed civil rights, those who opposed racial equality, those who opposed racial integration. They saw these messages as being so incendiary and so dangerous, so threatening to their way of life, so upsetting emotionally. I've read some of the cases from the lower courts, even state Supreme Courts in the United States South, said that to have black and white students demonstrating together for integration and holding hands and singing. This was one of the great anthems of the civil rights era. Black and white together. Those words are violence. And therefore, they can be shut down because those violent words can be expected to cause violent retribution on the part of audience members. And I just have to smile because those are exactly the same arguments that are being made today in the United States by college students with respect to exactly opposite messages, right? That somebody who might take a critical view, for example, of race-based affirmative action or of defunding the police because the police are supposedly an inherently racist institution. Those words are violence, and therefore we should be able to silence the speaker. And so it's always so helpful to have examples in mind and to have this humility. Be careful what you wish for when you think this is a legitimate tactic to silence speech that you disagree with. It's going to come back to bite you and silence speech that you very strongly agree with.
Yes, absolutely. And it actually seems to me that the current wave of censoriousness has more in common with the enemies of the civil rights movement than might first meet the eye. I mean, I've read that at least some elements of that movement want to divide the races again and have separate spaces on campuses for black students who purportedly don't feel safe in mixed spaces, and they've basically reinvigorated the idea of race as a dividing category in society.
As a defining characteristic. And yes, that is troubling. In one sees it at every level of education, starting with some public schools having exercises in the name of, here's the label that we use in the United States, diversity, equity, and inclusion, DEI. Wonderful goals. Who could oppose those goals? But to me, kind of an Orwellian twist on the concept, starting with exercises in the lowest grades of having students being subdivided into racial categories and being taught that all whites are oppressors and all non-whites are victims. Now, hopefully this is not a pervasive practice, but if it occurs even in one school, that is too often. At the other end of the educational spectrum, we have many graduation ceremonies now, including at the most prestigious universities, where there are separate commencement events for Black students and then for the rest of the student body. It's an issue that perhaps is tangentially related to free speech, but I do see connections, and one of the connections is that I think there is a lot of self-censorship in discussing. So the fact that I can feel comfortable even discussing this is not something I would take for granted, because I assume that many people who would share the same discomfort or at least questions about these policies might not dare raise even the questions, let alone potential arguments against it, for fear of being accused of being a racist, even for wanting to explore the matter.
Yeah.
I mean, that's what a lot of the surveys that Heterodox Academy has conducted in the States have shown, that people would like to talk about these things, but they feel that there's this chilling effect of people being punished. When they see one person being punished for speaking out, then they all think that might happen to me too. And we've seen that in New Zealand too. The Free Speech Union did a survey of New Zealand academics, where I think more than half of them said they felt more hindered than free to talk about one issue in particular, which was the Treaty of Waitangi, which plays a big role in this country in race relations, because it was a treaty between Maori tribes and the Crown. But we've also done a survey as part of Heterodox New Zealand of undergraduates in New Zealand, and we find the same results, that they feel significantly hindered or chilled to talk about the topics that you would expect. So issues to do with sexuality, gender, religion, politics, all those things.
I read that excellent co-authored study. I think James, were you a co-author?
We both were. Actually.
You both were co-authors,
yeah.
Right? Thank you. I read that with great interest, and let me use this as an opportunity to anticipate one of the counter arguments that I'm always getting in the United States, which is, but isn't self-censorship good? Isn't it an effective exercise of our free speech rights to decide not to say certain things? And the answer is, as with respect to all of these issues, that it is a matter of degree, right? A phrase that we use in the United States with respect to many civil liberties and constitutional law issues is, it is a delicate balance. Yes, we as individuals are free to choose what to say, what not to say, how to frame what we say in order to communicate in an effective manner. That is an exercise of free speech. So choosing not to say something that is, you can predict is going to be deemed insulting to somebody is an exercise of free speech. But it goes too far when your reason for self-censoring is not because you are, avoiding intentionally insulting somebody, but because you are afraid that even touching on an issue or suggesting a certain perspective on an issue is going to be falsely raise a false accusation that you are discriminatory in some way. Now again, so I'm doing the pro and the con. I'm always trying to see all plausible perspectives on all issues. That's consistent with intellectual freedom and rigorous inquiry. I think it's very positive that our societies have arrived at a stage where one of the most stigmatizing insults that we can hurl at somebody is, you are a racist, or you're a transphobe. We so value individual, equal individual rights and dignity, regardless of who you are. That is wonderful. I wish we would extend the same egalitarian protection and dignity to whatever you believe, whatever you think, right? And my sense of a really robust concept of DEI on universities and elsewhere would be that we have to have diversity and equality and inclusion, not only of every identity characteristic, but also of every ideological and theological and philosophical belief.
Yes, the diversity of viewpoint is the one category that seems notably lacking. I take your point about there being a kind of spectrum of willingness to speak up and politeness and so on should play into how we conduct discourse. That's not precisely a free speech issue, because people should be ultimately free to be rude, but we like decorum. I guess for me, an important dividing line between what we should perhaps consider not saying and what we should say is whether we're discussing an idea or engaging in ad hominem or personal attack. And it seems to me actually the people who want to shut down open discussion are very free with ad hominem, using the word racist or homophobe or transphobe or whatever it is quite freely, without justification very often. And those accusations can themselves have terrible repercussions for people, because our culture of open debate has become so fragile that people lose their jobs simply for being called something.
Yes.
And that seems to me an egregious attack on free speech.
You know, there's consistency is a hobgoblin of little minds, right? But we consistently, I'm laughing as I say that, I do consistently see inconsistency or hypocrisy, if you will, in the asserted standards for appropriate speech, because not only are the insults of various kinds of ists and obes being hurled freely by those who say that, you know, words are harmful and words are violent and should be suppressed, but even beyond that, in the genre of speech is violent. I don't know how closely you followed recent events at Stanford Law School, one of the most prestigious academic institutions in the United States, one of the most selective, supposedly going to be generating future leaders of the legal profession, government, and the judiciary. Students on the left were demonstrating very disruptively against a leading federal judge in one of the circuit courts of appeal, which are right below the U.S. Supreme Court. And, you know, not only were they using the kind of terminology that you've referred to, Michael, but they were using vulgar sexual language toward him. And I thought among the most disturbing shouts that were hurled at him was, "We hope your daughters get raped. We hope your daughters get..." Now, this is an understatement of the year to say, as a law professor, I cringe at future lawyers believing that this is an appropriate way, let alone an effective way, to express disagreement with the judge's ideas. But it's even worse when the person who is saying that is accusing the judge, because of his rulings that they don't like, of committing violence against people, and then to use that overtly violent language against females, and presumably young people, his daughters. So, you know, maybe to take something positive from this troubling episode, perhaps I would defend the right of the students to hurl those epithets, but I would then beg them to understand that the principle that shields them when they choose to exercise their free speech rights that way, certainly extend to the judge's free speech right to express his views, and not to mention the free speech rights of audience members to hear those views.
That's an important consideration. And this notion of defending the right of people to be offensive, I mean, that has a long history. I mean, I know that you were also president of the American Council for Civil Liberties in the 1990s. And I think you knew Ira Glasser, who was, I think you said he was the coordinator.
He was the executive director and I was the national president.
Now, of course, he famously, this is one of the most bold and courageous defenses of free speech in history, as far as I'm concerned, defended the right of Nazis to march through Skokie in Illinois, through a Jewish community where a lot of Holocaust survivors were living. And he, as a Jew himself, defended the right of these Nazis, these very offensive people, to have their say.
It's even more dramatic than that, which is, Ira was then the executive director of the New York Civil Liberties Union. The national director of the ACLU, American Civil Liberties Union, was R.E.A. Nyer, who was himself a Holocaust survivor. R.E.A. was born rather late. He was a child when Hitler came to power, and his family ultimately, his immediate family ultimately was able to escape from Europe. His extended family was completely slaughtered by the Nazis. And so he could not have had more loathing for the Nazis' message, and took a lot of recriminations from the Jewish community as well as from ACLU members. I mean, there's a paradox. The principle that the ACLU defended in that case has been called by the U.S. Supreme Court the bedrock principle of free speech. It's usually referred to as viewpoint neutrality or content neutrality. Government must remain neutral with respect to the viewpoint, the content, the idea of the message. Merely dislike of the message or disagreement with it can never be a justification for suppressing it. If in a particular context the message, presents an emergency, intentional incitement to imminent violence or targeted harassment or, a threat, then in the context it could be punished, but never solely focusing on the viewpoint, which was the only allegation in that case. So it was just, a hands down winner in the courts of law. The case went all the way to the Supreme Court and we won. But it was a real loser in the court of public opinion, even in the United States, with a strong free speech tradition, and even among ACLU members. People who care strongly enough about free speech that they became card-carrying members, paid membership fees. We lost about 15% of our members over that case, which is, very sobering, but it also provides historic perspective when people say to me, why are liberals now abandoning free speech? And I say, we've always had a problem all across the political spectrum. Liberals have always hated certain speech and been uncomfortable with defending it. I should put a time marker in here. The Skokie case was in the 1977 to 1978. And, so there have been some kinds of speech that have made liberals very uncomfortable and other kinds of speech that have made conservatives very uncomfortable. We often say that as a realistic matter, most people in the United States, and I dare say around the world, believe in freedom of speech for me or people like me, but not for thee.
Yeah.
And so it's so important to keep reminding people that if you want freedom of speech for me, then you're going to have to, as a practical matter, defend it for thee as well.
What you said there about the content test, that you can't shut down free speech because of the content of what someone's saying or the viewpoint expressed. I think that's very important even now because, you often get this back and forth with campus issues where someone gets shut down effectively for a viewpoint like that women can't become men. And then you say free speech and someone says, well, you don't really believe in free speech because you would agree that perjury should be banned. And you're like, yeah, I agree that libel should be banned as well. But that's not what we're talking about in these cases, right? Usually in these cases, we're actually talking about people being shut down because of their viewpoint.
And it's such an important distinction, and it's really not appreciated as much as it should be, even by lawyers in the United States. So it was one of my big insights as a result of reading so many cases, and I've now finished writing my second book in the past few years about free speech, because we have a legal system, which I'm sure is similar in this country, where it's the case method. And so the law develops case by case, and each case has different factual scenarios. It's not written out like a code. So you have to kind of piece together what the law is, and the patterns only emerge over time. And what I realized very clearly is that these free speech principles, which are shared by other countries, really make a great deal of common sense. They do allow government to punish the speech that is the most dangerous, speech that poses an emergency because it imminently and directly causes certain specific harm, and the harm is not disagreement with the idea. So perjury, to use your example, James, merely by being uttered interferes with the administration of justice. Fraud, a false statement made intentionally for somebody to rely on it to that person's financial detriment. That is punishable because that is a tangible, demonstrable harm that has nothing to do with disagreement with the idea of the speech. So when speech, these exceptions are not really exceptions to the core principle of free speech, that disagreement or disapproval of the idea or the viewpoint is never a permissible justification. These aren't exceptions. Now, in fairness, I have to say, American law does contain one exception, one anomalous exception to that viewpoint neutrality principle, which is very controversial, but the Supreme Court has not revisited it since 1973, and that is the so-called obscenity exception. So, I mean, it kind of puts in stark relief the speech protectiveness of the rest of our law. But basically, back in 1973, over, a strong dissent, 5-4 ruling, the court said a subset of sexual expression defined totally in terms of its content, that it's patently offensive, that it appeals to the prurient interest in sex, that it lacks serious value. These are all based on the content, that is a justification for censoring it. That would not be a justification for censoring any other controversial material, whether it be hate speech or extremist speech. And I think, many people say this goes back to America's puritanical heritage. We've just always been very suspicious of sexual content.
It's interesting, isn't it? And I know you've written a book about pornography as well, and defending the right of pornographers and pornographic performers in the name of free speech. What led you to do that?
People are always, Nadine, why are you defending pornography and hate speech and terror speech? Because that is the speech, disinformation, that is the speech that is attacked, right? I am defending neutral principles, which people find to be completely uncontroversial when it comes to applying them to speech that they like. But it's in the context of controversial speech, which in my country certainly includes sexually oriented speech as well as hate speech and the others, that one has to explain why the principles must be defended in those contexts as well. And a really important point, Michael, when the term pornography has no specific legal meaning in the United States, and the dictionary meaning is expression. The etymology, I guess you will know that as a classicist, James, has to do with writing about prostitutes. People use the term to stigmatize whatever sexual expression they dislike. So, it's a little bit, and this is where the famous or infamous phrase, "I know it when I see it," was first used by a Supreme Court justice who was trying to define the subset of sexually oriented expression that the court labels obscenity and says is constitutionally unprotected. He, in all seriousness, said, "I cannot define it, but I know it when I see it." And I understand that your prior prime minister used that exact phrase, apparently also not ironically with respect to hate speech.
That's right. The legislation they had drafted was so ill-defined that neither she nor her justice minister was able to say whether, for example, baby boomers who were vilified by the younger generation for having a monopoly on the housing market, whether the people who accused them of that could be had up for hate speech. And
yeah, because the law had a provision in it that you're not supposed to incite ill will or hatred or contempt towards anybody, any group defined by a huge number of different ways. And one of the ways in which groups could be defined is by age. So it was a perfect question. It was a good question because, baby boomers are a group defined by age. So would people have the right to stir up contempt or ridicule, even by posting something on Twitter about, all the damn baby boomers have bought the house, the baby boomers have bought all the damn houses or something like that? And the journalist Tova O'Brien asked this to the Minister of Justice at that time, Chris Fafoy, and he just couldn't answer. And I mean, it was astonishing that the legislation was drafted so badly, I have to say.
But this points out that the second major common sense point about free speech principles, the first one being that government may restrict and punish the speech that is the most dangerous, the most harmful, because of the imminent or direct harm that has nothing to do with ideas. But the countervailing principle is that the most dangerous censorship is restrictions that are based solely on dislike of the content or disapproval of the content or the message, because that is so inevitably subjective. Whether you call it pornography or whether you call it hate speech or whether you call it disinformation, the honest, and, I appreciate the candor of your prior prime minister in acknowledging and the Supreme Court justice that it really comes down to you have to trust us, those of us who are enforcing it, to make the right decisions about which of the vast universe of speech that could be labeled with these vague terms. We'll pick the ones that are the important ones. And so it's not surprising, in fact, it's completely predictable that when you look at how all laws under all of those labels have been enforced around the world, the pattern over and over and over again is it's speech that is in the minority, that's unpopular, whether because of political protesters or dissidents or members of disempowered minority groups. And that becomes especially ironic when you talk about hate speech, because the laudable goal of those who advocate it, and I certainly share that goal, is to increase the belonging and equality and participation in society and in government of people who have traditionally been marginalized. But that is not how the laws work in practice. And one of the, to me, very interesting and important conclusions of the research I did for my book about hate speech, which I wrote in 2017. I had followed these debates very closely in the United States, but I hadn't followed every recent development around the world. And I was just struck by how many human rights activists in countries around the world, in the United Nations, and other regional human rights agencies, opposed hate speech laws that went beyond, what I defined earlier, speech that intentionally incites imminent violence and so forth, laws that empower government to punish the speech solely because of the content of the message, that this was opposed by people in so many other countries, not because of free speech concerns per se. The laws were perfectly consistent with their own legal systems, but because of the counterproductive impact of the laws, specifically on the human rights goals of empowering and equalizing the status of traditionally marginalized groups.
Right, yeah. Well, we're very pleased that for the time being, at any rate, the hate speech legislation here has been pushed back. We can't say it's been utterly defeated. It's been referred to the Law Commission. And look, this is probably a good time to thank the Free Speech Union very much for hosting your visit. And I believe that you and Jonathan Ayling, the Chief Executive of the Free Speech Union, visited the Law Commission. Is that right?
Yes, and thank you for acknowledging the Free Speech Union, which I have to say I first became aware of at its very inception, which I believe was 2018, when it was organized under the name of the Free Speech Coalition. One of the founders of the organization, Stephen Franks, had read my book on hate speech and reached out to me about free speech controversy here, where local government had made public facilities available, as it routinely does, to certain speakers at the behest of a community organization. And then the permission was withdrawn because of the allegedly controversial viewpoints that the speakers were anticipated to be propounding. And that is obviously inconsistent with fundamental viewpoint neutrality and not to mention due process and other important principles. So I have been a enthusiastic supporter and follower of the activities of the Free Speech Union ever since. I receive your newsletters and cheer you on. Yesterday, and I want to thank Jonathan Ayling, who is so energetic,
Yes,
and I encouraged him to fill up my schedule as much as possible, because that's why, much as I love being a tourist in your beautiful country, I even more prize the opportunity to talk about free speech and do whatever I possibly can to assist in the effort to support it here. So one of the meetings that Jonathan organized yesterday, he referred to as an interagency meeting, because there were representatives not only of the Law Commission, in particular the president of the Law Commission. The commissioner was supposed to also attend, but sadly she had a death in the family, so was not able to be there in person, but ably represented by the president. And there were also representatives of other important government agencies. I'm not going to remember the exact names. I think the Department of Internal Affairs, MEC, the Ministry for Equality, or for ethnic communities, another law enforcement body, the Human Rights Commission, all participated in what I believe we all agreed, I had positive comments afterwards, was a very candid and generative and constructive discussion about where do we go forward with the remit to the Law Commission to start from scratch and coming up with proposed hate speech legislation. And what I found, what was so encouraging, was that people didn't necessarily start with the assumption that there should be new legislation, that the task that we face and the goal that we all share is reducing hatred and discrimination And maybe the way to do that isn't through laws, whether
Right.
through criminal laws or through civil laws. So we spent a lot of time talking about educational approaches, talking about civil discourse and dialogue, talking about information, both online, and this gets to one of your big areas of expertise and concern, Michael, through the primary elementary educational system.
Yes. I'm very interested in that one. So, I mean, I'd be interested in any reflections that came out of that discussion. I do think about this a lot, and, you know, I think it's great if young people are taught about the institutions of their country, the way their government works, the way elections work, and so on. I don't think, though, that is remotely enough to instill the value base that will maintain the spirit of free speech and open debate and open society. I mean, reading Jacob Mchangama's book is an object lesson in how fragile those values are, and how many times in history they've been victories, but also steps backward. And it seems always it's a constant effort that every generation has to engage in, or we will end up losing those values. And I'm concerned that that's what's happening now. So I'd be interested in your reflections and anything that came out of that discussion about what we might be doing in primary school beyond teaching people directly.
Yes, one of the mottos of the ACLU, the American Civil Liberties Union, which is attributed to Thomas Jefferson, but it may be apocryphal. If he didn't say it, he could have said it. Eternal vigilance is the price of liberty. And in the United States, major cultural battles throughout American history have been fought in the context of the public schools, the lower grades in particular, because of mandatory education laws. That's where you can count on everybody being required to attend, and the recognition that this is an opportunity to instill values and habits of mind that will be either freedom friendly or the opposite. In fact, you know, one of my intellectual heroes, John Stuart Mill, opposed the whole institution of public schools because he thought they're inherently indoctrinating, and that's an inappropriate role for the government. I believe that through proper, what I would consider proper positive education, the schools can and should be opportunities to stimulate precisely the kind of critical thinking that Mill also championed. And you do that, as you suggest, Michael, by not telling students what to think, not teaching them what to think, but teaching them how to think. Yes. And there are a lot of curricular materials, which I did mention to the folks at the meeting yesterday, because there's such intense interest in these issues in the United States, that their wonderful materials are available through all kinds of online sources, including some of the organizations that we've already referred to, FIRE, the Foundation for Individual Rights and Expression, but which long was Foundation for Individual Rights and Education and still has a big educational focus, the Heterodox Academy. A growing number of universities have entire departments and schools on what they call civic engagement and civil discourse. And, you know, and foundations have been putting a lot of money into this. And it's all, you know, once you start going down the online rabbit hole, you can find materials that are designed for every level of education, every level of sophistication. And I think, you know, drawing on expertise about psychology and education and philosophy, so that and which go beyond the schools, by the way, because in the United States, surveys show that the vast majority of us are hungering for opportunities to meet and talk with people that disagree with us, that are different from us, about the hot button issues but in a trusting fashion, where we're not going to be stifled by fear of being accused or defamed as a racist. One organization is called Bridge USA, another one is called Hidden Tribes, and we actually see a flourishing of ordinary people coming together, meeting in a local library or a local restaurant to engage in getting to know each other and expand their empathy and understanding.
Yes, it's one of the silver linings to the cloud of the attacks on free speech, to me, that it is bringing together people who perhaps in other circumstances wouldn't have found common cause. I saw that last night at your event with the Free Speech Union. People of all different stripes, from those who had been perhaps angered by the Posey Parker event, the radical feminist types, and then what I might term as grumpy old men, and others who were objected to their treatment by the government and their inability to speak out against vaccine mandates and the like.
And somebody came up to me afterwards to complain very politely about the Free Speech Union coming to the defense of drag queen.
Story Hour.
Story Hour.
Yes.
And which is, and she was very respectful when I explained why I thought it was consistent with the free speech principles that she generally supported and was not posing a danger to children, and she seemed open-minded about that. But I thought that was interesting because I've heard many people say, the Free Speech Union is defending conservative points of view, which is fine, but obviously defending points of view on the liberal end or progressive end of the spectrum as well.
It's a good lesson for people, I think, that who come with one particular complaint because they or their cause has been subject to some kind of censorship, to realize that there are others who they might disagree with who have similar complaints.
So one of the things we wanted to talk about a little bit was education, because it seems we've been talking about schools and universities, and it seems to me that there is a different situation with free speech in schools and university. For example, with a school teacher, you might expect them to sort of teach the curriculum. Schools may be a place for exploring ideas, but not as much as universities, right? And with university lecturers, they're also doing research, so you should expect them to have sort of greater leeway. But I thought I heard you say last night that academic freedom and freedom of speech are different. So with a lecturer or a university professor, for example, imagine they're in a department of geology and they're a young Earth creationist. They believe that the Earth only was created 6,000 years ago. Did I hear you correctly in saying that it might be justifiable for a department not to hire that person or to fire them for those views because that's not protected by freedom of speech? They have freedom of speech as a citizen, but not necessarily as an academic. And I don't know quite what I think about that. I'm kind of developing my views and thinking out loud, but it strikes me that there are a lot of difficulties with this because nowadays, for example, there might be sort of gender studies departments, and as far as I can tell, like a lot of what they think is, in my opinion, not scientifically correct. So you might have a situation where someone could get fired for a gender studies department for believing, for example, that there are only two sexes in Homo sapiens. Does that complicate matters?
It's a complicated issue, and a lot has been written on it in the United States recently, precisely because of the complexities that you point to, James. I would refer you, for example, to an excellent recent article by Keith Whittington, who is a political science professor at Princeton and one of the founders of the Academic Freedom Alliance, and he'll cite a number of others. So let me start with what I think is the simple and fundamental point here. And in fact, I think the principles, as always, are relatively easy to state. The difficulty and the debate comes in the judgment calls when you apply the principles to particular situations. So the simple principle is that a professor or a student, a member of the faculty, has exactly the same free speech rights in the general world, in the general public sphere, as everybody else. You do not give up one iota of what we call your free speech rights as a citizen by virtue of being a faculty member. But as with, and this may be a difference between New Zealand and the United States. In the United States, in your capacity as an employee, whether it be as a, employee of Google or an employee of Harvard University, you have fewer free speech rights on the job. The employer may, and this is true in a law firm as well, the employer understandably may demand as part of your job responsibilities that you not address certain topics or not air certain perspectives on the notion that those are inconsistent with your primary responsibilities as an employee. So your primary responsibilities as an academic are to produce academically sound scholarship and to teach the topic that you are hired to teach. So to take a simple example, you may have a right to express your opinion about a free speech controversy as a professor, but if you're teaching a math, on your social media, in writing an op-ed column, so forth, but you may not, in the middle of a math class that you've been hired to teach, spout off any views about any other topic, right? Mm-hmm. Now, the American Association of University Professors, which was founded in 1915 to expound the principles of academic freedom, and basically that is considered the gold standard, which has pretty much been ratified by the U.S. Supreme Court subsequently as being implicitly protected under the First Amendment free speech guarantee. The AAUP has said that when you look at the professional communications and expression of a professor in conducting research or teaching a class, it is appropriate and permissible to discipline somebody for violating professional norms. So an example that I gave last night in response to another follow-up question about this was if somebody uses, investigative tools that are accepted for that discipline, and in my discipline that would mean looking at the U.S. Constitution, looking at Supreme Court cases that interpret the Constitution, looking at statutes, looking at scholarly articles, any plausible perspective that's generally consistent with the relevant authorities should be protected, even if it's a very controversial minority conclusion that you reach. If, however, I said, I don't care about what the Constitution itself says or what the original intent was or what the Supreme Court has said, but God has spoken to me, and and I say this with the deepest respect for religion, but in its place, if I say God has revealed to me that, abortion is a protected constitutional right, that would not be a legitimate professional approach. Mm-hmm. I could be subject to discipline, right, or even firing. And the example that you give, James, strikes me as a clear example of something that should be protected. Somebody using accepted methodological approaches to reach controversial conclusions.
Yeah, my worry there is just that there's a lot of diversity and viewpoints in the modern academy, mm-hmm, even with regard to methodology. Mm-hmm. So it might be that the other gender studies scholars said to the person, reaching these horrible conclusions that there are two sexes, you're using evolutionary psychology, and that's not the appropriate, mm-hmm, methodology to use. So,
that seems to me to be something that's debatable, but that would cut both ways, because I would defend freedom for somebody whose methodology and conclusions I might well disagree with. Yes, but I think I'd rather err in favor of being too generous.
So would I. I mean, I'm a trained scientist, and I'd take that as a case in point. And actually, there are a lot of parallels between the way ideas are contested in democracy and the way they're contested in science. And I would much rather have people make crazy claims than shut down the potential for productive debate. And so I think that actually people making crazy claims is usually a self-correcting problem in academia, because people won't take too much notice of them. They'll struggle with the peer review process. People won't turn up to their seminars after a while. And I would prefer to have those people be able to say crazy things. And actually saying crazy things has in the past in science turned out to be rather productive. Somebody once made a crazy claim that the Earth was not at the center of the universe, and somebody else made a crazy claim that we were descended from ape-like ancestors, and then someone else named Albert Einstein made the crazy claim that velocity is relative to time, and time to velocity. You see what I mean?
I do. I would be fascinated, Michael, if you could explain how the listener's controversy here fits into this discussion that we're having.
Oh, well, so many of our listeners will be quite familiar with this case. About a year and a half ago, there was a letter to a publication called The Listener by 7 Auckland professors who were concerned that mystical claims in the name of Mataranga Māori, being Māori traditional law, were being infused, or the Ministry for Education intended to infuse them into the science curriculum. And they wanted to keep science as a discipline that did not include sacred claims. And so they published a letter to that effect. And then there was a hue and cry. They were called racist. They were called harmful, all sorts of things.
Would you say they were not being generous enough? I'm just going to quote you about crazy claims.
Well, I do make a distinction between research and teaching. So I absolutely agree when you say that you shouldn't be able to just say whatever you like in a lecture or in a school class, because there you have a duty, I think, to be instilling the body of knowledge which has been established by a discipline. But when it comes to research, I think that's where the crazy claims ought to be able to be explored. That would be the distinction.
I think also that their letter is a genuine example of counterspeech, right? Because we often get this objection, oh, that was just counterspeech. And I think in the case of an episode like the Posey Parker thing, I mean, most people who were at that protest genuinely were exercising counterspeech. They were holding up signs and shouting, as long as they weren't trying to shout down. But the people, the few people punching and elbowing people in the face, that's not counterspeech. But I think that what the listener letter writers were up to is just saying, we disagree with this claim, and I think that's perfectly appropriate. And then what was illegitimate was the supposed counterspeech on the other side took the form of, for example, the Vice Chancellor of Auckland saying that their letter caused harm and dismay. Now, I know that's not punching someone in the face, but I think when it gets to the level of sort of university authorities and also the Royal Society, which actually commenced an investigation against some of the letter writers, when it gets to that kind of people with real institutional power, I do think that crosses a line that ceases just to be debate. Right. They could have. I mean, the Vice Chancellor, I think, would have been better off just saying, "I disagree with this discrete claim.
Yep.
I respect my colleagues for putting this view forward, but I disagree with it." That would have been much better.
I'm smiling, wearing my teacher hat, because this incident is such a fertile ground for exploring so many of these issues of principle that we've been talking about.
It is. And unfortunately, we're unable to explore them much further, because I think I've got to get you back to your hotel very, very soon. But it's been absolutely delightful, and we could go on for another 2 hours, I suspect. But
let me thank both of you also, not only for your support of the Free Speech Union, but also for your involvement in the Heterodox Academy, another important institution, and for so effectively exercising your freedom of speech as well as defending other people's.
Well, thank you for your work, and thank you for being on Free Kiwis.
Yeah, thanks very much.
You're very welcome.